Hello everyone. Welcome to week 6 of the I.E.P Support Series. My name is Janine Dixon and I'm the Special Education Advocate at Cornerstone Educational Consulting. We are presenting this in collaboration with Red State C.A.R.E.S, a nonprofit out of Baton Rouge, Louisiana, that works with the community to build social, mental, and behavioral health through human connection. Let's get started. This week, what's happening is we are going to talk about behavior, discipline, and children with disabilities. The materials that you may want are the acronym dictionary. There are so many acronyms in special education world, and maybe a printout of these week 6 materials to take notes. Lots of different rules for kiddos with special needs in regards to discipline. I like to say that we're under our own umbrella when it comes to being disciplined. And I really like that we're under our own umbrella for this reason. If we were to punish children with disabilities the same way as we punish children without disabilities, a lot of times, essentially, we would be punishing a kid for a disability that they cannot control. And so we realized this at some point and put some special rules into place to kind of cover our kids or get up underneath this umbrella. So when a student with a disability does break a school rule or needs to be disciplined, we really have to think hard about how we're going to do that and where we're going to do that. The services that shall be provided to a student with a disability who has been removed from their current placement or like what their normal day looks like might be provided in an interim alternative educational setting. So we might send a student with special needs to the TOR, the timeout room, or ISS, in school suspension, or a special place either on campus or in a different place. In which case, we may decide that we need to continue special education services. Now, I know that there are you guys out there saying, well, my kids had out-of-school suspensions and we didn't get any kind of services. And you're absolutely right. The LEA, or Local Educational Agency, or the school, is only required to provide services to a student with a disability who has been removed from his or her current placement for 10 consecutive school days. Now, there are a few caveats to that, and we will talk about them later in this program. When a student with a disability gets in trouble, like I said, the school has 10 days. They can discipline our kids with special needs for up to 10 days before this manifestation determination review has to take place. Some schools will do it a little more proactively just to make sure that they are meeting the student's needs. But after that 10-day mark, this manifestation determination review has to take place. And that is a meeting to review the relationship between the child's disability and his or her behavior that needs the disciplinary action. In other words, did this child with a disability have the executive function and the decision-making skills to know that, oh man, what I'm about to do is wrong, I'm going to do it anyway? Or was it something that their disability prohibited them from realizing, like, this is not a good thing and it's going to cause a ruckus and it's going to cause me to get punished? So we're not wanting to punish kiddos for their disabilities. People have tried throughout history to punish the disability out of a kid, and spoiler alert, it doesn't work. If the removal is a change of placement, the student's IEP team determines the appropriate services to enable the student to continue to participate in the general education curriculum, although in another setting, and to progress toward meeting the goals set out in the student's IEP. So if we're sending a kid to the timeout room or in-school suspension or somewhere else on campus, whatever your school calls that place, we need to determine what are the services that the student still needs and able to access the curriculum. So, what accommodations, what modifications, what related services do they still need to be receiving in order to make progress toward their goals? Within 10 school days of any decision to change the placement of a student with a disability because of violation of the Code of Student Conduct, the LEA, Local Education Agency, parents and relevant members of the IEP team shall review all relevant information in the student's file. And we're looking to determine a couple of things here. The first thing we're looking to determine is if the conduct in question was caused by or had a direct and substantial relationship to the student's disability, or if the conduct in question was a direct result of the LEA's failure to implement the student's IEP. Now remember, a student with an IEP that has behavioral issues that are known to the staff should have had a functional behavior assessment to determine why the behavior is happening, and a behavior intervention plan so that we can try and modify or improve the student's behavior. So if yours is a student that has had an FBA and has a BIP in place, we need to look through there and we need to see, did the school provide those support services with fidelity, or was it a failure to implement that caused this behavior? If the school, the parent, and the relevant members of the student's IEP team determined that either of those conditions were met, so the misconduct was a direct result of or caused by the disability, or the school did not provide the support services from the behavior intervention plan with fidelity, then the conduct of the student must be determined to be a manifestation of the student's disability. If the school, parent, and relevant members of the child's IEP team determine that the conduct in question was the direct result of the LEA's failure to implement the IEP, remember that includes the behavior intervention plan, then the school shall take immediate steps to remedy those deficits. So in other words, the onus falls on the school then, not on your child. Determination that a behavior was a manifestation of the child's disability. If it is determined that the conduct was a manifestation, the IEP team shall conduct a functional behavior assessment unless they've already done one before and the behavior that resulted in the change of placement occurred, and implement a behavior intervention plan for the student. Or if these things have already been developed, we need to review them, modify it as necessary to address the behavior, and then continue using that behavior intervention plan with fidelity with the new changes. Except as described below under special circumstances, the school must return the student to the placement from which he or she was removed unless the parent and the school agree to a change of placement as part of the modification of the behavior intervention plan. So it's a whole lot of words that really just means if we say, yes, okay, the behavior was a manifestation of the disability, then after all of this happens, then the student goes back to the classroom that they were in, or the classes, the schedule that they had before the behavior occurred and the student was removed, unless the parents get with the school and they agree, like, yeah, actually, we think maybe he needs a more restrictive environment. Maybe he needs to spend some more time in the resource room. Maybe he needs a different plan. But we need to agree to those things. The special circumstances are what I call the big three. So schools can remove a student to an interim alternative educational setting. Sometimes those are known as the alternative school or the behavior school, but not for more than 45 school days or a 9 weeks period, without regard to whether the behavior is determined to be a manifestation of the disability or not. So these three things will get your kid kicked out to the alternative school for 45 days. Now, the 45-day thing is essentially an expulsion. So a typically developing student would be expelled for these things. Our kids will get a 45-day removal. If they, number one, carry or possess a weapon at school, on the school premises, or at a school function under the jurisdiction of the Louisiana Department of Education or the LEA. Number 2, knowingly possesses or uses illegal drugs or sells or solicits the sale of a controlled substance while at school, on school premises, or at a function under the jurisdiction of the LDOE or LEA. And number 3, has inflicted serious bodily injury upon another person while at school, on school premise, or at a school function under the jurisdiction of the Department of Ed or the school. So if your child brings a weapon, if they've got illegal drugs, or they cause serious bodily injury, they can be put out for 45 days. Done. Let's talk a little bit more about what these 3 things can look like. So a controlled substance means a drug or other substance identified under Schedules 1, 2, 3, 4, or 5 of the Controlled Substances Act. An illegal drug means a controlled substance but does not include a substance that is legally possessed or used under the supervision of a licensed healthcare professional, or that is legally possessed or used under other authority under that act or under any other provision of federal law. Serious bodily injury means bodily injury that involves a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss or impairment of the function of a bodily member, organ, or faculty. This is really important. I have had clients of mine that have been suspended, and I kid you not, for hugging a teacher who said she didn't want to be hugged, and they called it bodily injury. We were able to overturn that because obviously a hug does not include substantial risk of death, extreme physical pain, disfigurement, or loss or impairment of a bodily function. But it does protect your kid if you understand these definitions. And then, of course, number 4, weapon has the given meaning of a dangerous weapon. If you want to know more, look up Section 930 of the Title 18 Code. Basically, no firearms, guys. Let's not bring that to school. Let's not bring knives to school. Let's not make knives at school. So notification. Obviously, we have to notify the parents of what is going on. So on the date on which the decision is made to make a removal that constitutes a change of placement of a student with a disability because of a violation of a code of student conduct, the school shall notify parents of that decision and provide parents with the procedural safeguards notice. So you guys might have noticed when you have your IEP meetings that you get a prior written notice letter or a prior notification letter, P&Ls, PWNs, we call them all kinds of different things, but you're provided with that document. So very similarly, this situation also comes with procedural safeguards for parents so that you can be a part of this decision, you can be a part of what is happening, and you know what's happening when it's happening. But what if we have to get law enforcement involved? Nothing in the regulations from special education or IDEA prohibits the school from reporting a crime committed by a student with a disability to appropriate authorities, or prevents state law enforcement and judicial authorities from exercising their responsibilities with regard to the application of federal and state laws to crimes committed by a student with a disability. In shorter terms, even if you have a disability, if you break the law, the police can still come onto campus and they can still arrest your child, just as they would anyone else who broke the law on school grounds. Transmittal of records. If the school reports a crime committed by a student with a disability, then the school shall ensure that copies of the student's special education and disciplinary records are transmitted for consideration by the authorities to whom the agency reports the crime, only to the extent permitted by FERPA. We'll talk a little bit more about the meaning of FERPA at the end, but it's kind of like the school version of HIPAA. So it is to protect confidential information. But if a student with a disability, is arrested and has to go to a different facility within the judicial system, the school will provide a copy of the disciplinary records and the special education records so that the student can continue to receive services wherever it is that they are placed. Change of placement due to disciplinary removals. A removal of a student with a disability from his or her current educational placement is a change of placement if the removal is for more than 10 consecutive school days, or the student has been subjected to a series of removals that constitute a pattern because A, this total series of removals total more than 10 days in the school year, or B, the student's behavior is substantially similar to behavior in previous incidences that resulted in the series of removals, and C, of such additional factors as the length of each removal, the total time the student has been removed, and the proximity of the removals to one another. Whether a pattern of removals constitutes a change of placement is determined on a case-by-case basis by the school, and if challenged, is subject to review through due process and judicial proceedings. So again, lots of lingo here. Let's kind of break it down. So I mentioned at the beginning that the school system could punish our kids with special needs for up to 10 days as they would punish a student without special needs. And when I initially read that, the language says 10 consecutive school days. But what if you have a kiddo that is showing a pattern of behaviors and got suspended the first time for a day, the second time for 3 days, then the third time for 5 days, and now we're up to 9 days. We've got 1 day left. That really should send up a red flag to the school. Because it is a pattern of behavior, we need to all sit down together as an IEP team. We need to create a functional behavior assessment where we look at the behaviors. We look at the antecedents, or what happened before the behaviors. We look at the consequences, or what happened after the behaviors, and try to determine why the student is engaging in this behavior. If we can figure it out accurately, then we are more likely to be successful in changing that behavior with a behavior intervention plan. So if yours is a student that is getting suspended constantly for kind of the same sorts of things, and your school has not yet called a meeting to create a functional behavior assessment, that is definitely something that you might want to ask for. But what about our kids that are not yet eligible for special education services? This one's really interesting. I think it's one of kind of my favorite things about the whole disability rights. If a student has not been determined eligible for special education and related services, and that kid violates a code of student conduct, but the school had knowledge, as determined in a future slide, before the behavior that brought about the disciplinary action that the student was a student with a disability, then the student may assert any of the protections described in this notice. So if the school knew, even if we didn't have an IEP yet, but the school knew, like, hey, this is a kid with a disability. Mom's been saying, like, hey, my kid needs an IEP. These things are happening. Here's some documentation. Then the school has to treat the student as a student with a disability. So here's the basis of knowledge. So if the school must be deemed to have knowledge that a student is a student with a disability, if before the behavior that brought about the disciplinary action occurred, number one, the parents express concern in writing that their child is in need of special education and related services to supervisory or administrative personnel of the appropriate educational agency or to the student's teacher. So if the parent has expressed in writing, which by the way, guys, please write everything in an email. If you write it down on a piece of paper or send it in a note in your kid's folder or even mail the letter, we don't have any proof that the person actually received it. And I don't have any proof of what you wrote. But if you write it in an email, then it's going to be time-stamped and it's going to be a permanent record of what you said. So if you think that yours is a child in need of special education and or related services such as speech therapy, occupational therapy, adapted PE, please write that in an email. Send it to the kid's teacher, send it to the principal, send it to anybody on campus that you think could help you take this to the next level. The school also must be deemed to be knowledgeable if the parent requested an evaluation related to eligibility for special education and related services under the Individuals with Disabilities Education Act, or if the child's teacher or other school personnel expressed specific concerns about a pattern of behavior demonstrated by the child directly to the school's director of special education or to other supervisory personnel of the LEA. Where that one can be a little tricky is that as a parent, I might not know if my kid's teacher has expressed these concerns unless the teacher tells me that they have, and then can produce the email documentation. An exception to this exception is that the school would not be deemed to have such knowledge if, number one, the parent or guardian did not allow an evaluation of the child or refused special education services or signed off on an official revocation of consent form. Or number two, the child has been evaluated and did not meet the criteria. So they were not determined to be a student with a disability under the Individuals with Disabilities Education Act. So if the school knew, like, hey, this could be a kid with special needs, and they did the evaluation, and then you as the parent refused the special education, or you signed a revocation of consent form, so you took your consent back, then it's kind of too bad. Your kid can be disciplined as a student without a disability. Or if your kid was evaluated and it was determined through the metrics and the data that was collected that your child is not a student with a disability, then also they don't qualify for this special education umbrella. So what to do if you disagree? So appeals. If you disagree with any decision regarding placement or the manifestation determination hearing, you may appeal the decision by requesting a due process hearing. And if you decide to do that, the documents that you need to fill out are on the Louisiana Believes website. So if you Google due process hearing form, Louisiana Department of Education, it should take you to a link that will bring you to that form. And so you'll need to complete the form, sign it, and then send it to the appropriate parties. All right, brain check. Is your brain melting? This is a lot of information. If you do have questions or you want some help, my information will be in an upcoming slide. You can also leave a comment on the video. All right, to add to your dictionary this week, we've got a few acronyms. MDR, Manifestation Determination Review. FBA, Functional Behavior Assessment. BIP, or some people call it a BIP, Behavior Intervention Plan. And then FERPA, of course, is our Family Educational Rights and Privacy Act. So again, that's kind of like the school version of the HIPAA compliance that we sign when we go to the doctor's office. All right, if you've been with me for the whole entire 6-week series, happy graduation. You did it. You made it all the way through. As of today, weeks 1 and 2 are up on YouTube. Had a glitch with weeks 3, 4, and 5, and now we're back for week 6. It is my plan to get weeks 3, 4, and 5 up as soon as I have a free moment to do so. All right, as promised, here is the information that you need if you need a special education advocate. I advocate all over the state of Louisiana, so please reach out if you are one of those parents who thinks, man, I really do not want to do this by myself. Email is the best way, and then I'll email you back a copy of the services that I offer, and you can kind of look through them and make the decision in regards to what supports you need. All right, guys, thank you for being with me for this semi-brief week 6 presentation. Remember, you have rights, and so do your kids. Thanks a lot.